The next judgment will be read by Justice, Honorable Justice Anukam. In the matter Kalebi Elisamehe versus United Republic of Tanzania.
Thank you, Mr. President.
28, 2015. You have the floor, Honorable Judge.
Thank you, Mr. President. This is the judgment of the court. The composition of the court is same with the one earlier read by my learned colleague. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, Justice Imani D. Aboud, a national of Tanzania, did not hear the application. This is the judgment of the court. In the matter of Kalebi Elisamehe, represented by Advocate David Sigano of the East Africa Law Society, and the United Republic of Tanzania is represented by Dr. Clement Mashaba, Solicitor General, Office of the Solicitor General, and 4 others. After deliberation, the court renders the following judgment. The parties, Kalebi Elisamehe, hereafter referred to as the applicant, is a national of the United Republic of Tanzania, who at the time of filing this application was serving a 30-year prison sentence at Mawani Central Prison in Tanga for the rape of a 12-year-old girl. The application is filed against the United Republic of Tanzania, hereinafter referred to as the respondent state, which became a party to the African Charter on Human and People's Rights, hereinafter referred to as the Charter, on 21st October 1986, and the Protocol on 10 February 2006. It also deposited on the 29th of March 2010, the declaration under Article 34.6 of the Protocol, by which it accepts the jurisdiction of the court to receive cases from individuals and non-governmental organizations. On the 21st of November 2019, the respondent state deposited with the chairperson of the African Union Commission an instrument withdrawing its declaration. Facts of the matter. It emerges from the record that on the 6th of March 2004, the applicant was convicted and sentenced by the District Magistrate Court of Mudali at Muduli District, hereinafter referred to as the District Court, to a 30-year prison sentence for the rape of a 12-year-old minor in criminal case number 39/2003. He was also ordered to pay the victim 1 cow valued at Tanzania shillings 200,000 as compensation. The applicants appealed against the judgment by the criminal appeal number 03/2006 before the High Court of Tanzania at Arusha, hereinafter referred to as the High Court. He subsequently appealed against the decision of the High Court by criminal appeal number 315/2009 before the Court of Appeal of Tanzania at Arusha, hereinafter referred to as the Court of Appeal. The High Court and the Court of Appeal upheld the conviction and the sentence on 9th July 2009 and 24th February 2012, respectively. Alleged violation. The applicant alleges, 1, that the Court of Appeal delayed in hearing his application for review to date. 2, that he was wrongly deprived of the right to be heard, specifically that he was deprived of his right to legal assistance throughout the trial and appeals, contrary to Article 13 of the Tanzania Constitution, Section 3110 of the Criminal Procedure Act, hereinafter referred to as the CPA, and Articles 1, 2, 3, 5, 7, 1 sub B, and 18.1 of the Charter. He also alleged that he was wrongly deprived of the right to be heard and to defend himself. He also alleged that the charge sheet was defective under Section 132 of the CPA because of the variance between the charge sheet and the evidence. And the charge sheet also bore no stamp or signature of the public prosecutor. Prayers of the party. The applicant therefore praised the court to allow his submission of complaints of violations of human rights and justice by quashing the decision of the lower court and set aside the conviction imposed on him. The applicant also is praying for reparation. The applicant praised the court to issue an order for pecuniary and non-pecuniary damages. The respondent state praised the court, one, to declare that it has no jurisdiction and the application has not met the admissibility requirement under Rule 45 and 6 of the rules. Secondly, to declare that it has not violated Article 711, 71C, and 71D of the Charter. Also to dismiss the application for lack of merit. Also to dismiss the applicant's prayers and to rule that the applicant shall bear the cost. Jurisdiction. The court notes that Article 3 of the protocol provides as follows. The jurisdiction of the court shall extend to all cases and disputes submitted to it concerning the interpretation and application of the Charter, this protocol, and other relevant human rights instruments ratified by the states concerned. And in the event of a dispute as to whether the court has jurisdiction, the court shall so decide. Having examined if it has jurisdiction, the court holds that it has material, personal, temporal, and territorial jurisdiction to hear the instant case. Also having considered the objection to material jurisdiction raised by the respondent. On admissibility, pursuant to Article 6.2 of the protocol, the court shall rule on the admissibility of cases, taking into account the provisions of Article 56 of the Charter. In accordance with Rule 39.1 of the rules, the court shall undertake a preliminary examination of the admissibility of the application in accordance with Articles 50 and 56 of the Charter and Rules 40 of the rules. Why some of the conditions in the Article 56 referred to are not in contention between the parties? The respondent state has raised two objections to the admissibility of the application. The first objection relates to the requirement of exhaustion of local remedies. And the second one is to the filing of the application within a reasonable time under Rules 40 sub 5 and 6 of the rules respectively. On objection based on non-exhaustion of local remedies. The court notes that the issue for determination is whether the applicant exhausted local remedies as required under Rule 40 of the rules. On this issue, the court recalls that the local remedies that must be exhausted are judicial remedies. In the instant case, the court notes that the applicant went up to the Court of Appeal, the highest court in the respondent state, which delivered its judgment on the applicant's case on the 24th of February, 2012. In relation to the filing of the constitutional petition and an application for review, the court has held that regarding the respondent state, these are extraordinary remedies which the applicant is not required to exhaust. Concerning the allegation that the respondent state failed to grant the applicant legal assistance, the court has previously stated that this is part of the bundle of rights relating to fair trial. In the light of the above, the court dismisses the objection hearing and holds that the applicant has exhausted all available domestic remedies. On the objection based on failure to file the application within a reasonable time, the respondent state argues that the period of 16 months from the time the Court of Appeal delivered its judgment to when the applicant filed his application is way beyond the reasonable time of 6 months suggested by the Commission in Majoro versus Zimbabwe case of 2008. The applicant does not make a specific response to this allegation, but maintains that he filed the notice of motion for review before the Court of Appeal on the 9th of January 2013, which the respondent state dismisses by contending that the applicant failed to submit before this court the copy of the said notice. The court notes that Article 56(6) of the Charter does not stipulate a precise time limit within which an application shall be filed before the court. Rule 46 of the rules refers to a reasonable time from the date local remedies were exhausted or from the date set by the court as being the commencement of the time limit within which it shall be seized of the matter. Since the application was obtained, the period to be assessed is 3 years, 8 months, and 29 days. The court knows that in the instant case, the applicant is lay, indigent, incarcerated, and was not represented by a lawyer before the national courts. As a result of his situation, the court granted the applicant legal assistance through its legal aid scheme. In these circumstances, the court holds that the application was filed within a reasonable time and therefore dismisses the respondent state's objection. Other conditions of admissibility. The court knows that the parties do not dispute the fact that the application fulfills the conditions set out in Articles 56 sub-articles 1, 2, 3, 4, and 7 of the Charter, and Rule 40 sub-rules 1, 2, 3, 4, and 7 of the rules. As a consequence of the foregoing, the court finds that the application fulfills all the admissibility conditions set out under Article of the rules and accordingly declares it admissible. On merit, the applicant alleges a number of violations of the right to a fair trial, namely the right to legal assistance, the right to defense, alleged defectiveness of the charge sheet, failure to review decisions of the lower court, poor assessment of the evidence, delay in determining the request for review. After deliberation, the operative part of the judgment is as follows. For these reasons, the court unanimously on jurisdiction dismisses the objection to the court's jurisdiction. It declares that it has jurisdiction. On admissibility, dismisses the objection to the admissibility of the application, declares that the application is admissible. On the merits, holds that the respondent state has not violated the applicant's right under Article 7, sub 1, sub C of the Charter to be heard and defend himself. It also holds on the merits that the respondent state has not violated the applicant's right under Article 7, sub 1, sub C of the Charter as regards the charge sheet being defective. The court also holds that the respondent state has not violated Article 14.5 of the International Covenant on Civil and Political Rights as regards the Court of Appeal and High Court's decision, basing their decisions on the findings of the District Court. The court also holds that the respondent state has not violated the applicant's right under Article 7.1d of the Charter to be tried within a reasonable time as regards the alleged delay by the Court of Appeal to review its decision to uphold the applicant's conviction and sentence. The court also holds that the respondent state has not violated the applicant's right to a fair trial as provided under Article 7, sub 1 of the Charter as regards the sufficiency of the evidence and the clarification of the circumstances of the case. The court also finds that the respondent state has violated the applicant's right to a fair trial provided under Article 7, sub 1, sub C of the Charter, as read together with Article 14, sub 3D of the International Covenant on Civil and Political Rights, by failing to provide him with free legal assistance on reparation, pecuniary reparation. The court does not grant the applicant's prayer for material damages for his imprisonment. The court grants the applicant's prayer for reparation for the prejudice suffered as a result of the violation found and awards him the sum of Tanzania shillings 300,000. The court orders the respondent state to pay the sum awarded above free from tax as fair compensation within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment until the accrued amount is fully paid. On non-pecuniary reparation, the court dismisses the applicant's prayer for his conviction and sentence to be quashed. The court dismisses the applicant's prayer for the court to order his release from prison. On implementation of the judgment and reporting, the court orders the respondent state to submit a report to it within 6 months of the date of notification of this judgment on measures taken to implement the orders set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On cost, the court decides that each party shall bear its costs. The judgment is signed by the same bench as earlier mentioned in the earlier case. Done at Arusha this 26th day of June in the year 2020 in English and French, the English text being authoritative. This is the judgment of the court. Thank you.
La décision 028-2015 dans l'affaire Kalebi Elisamehe, Tanzania, contre Elisamehe contre République unie de Tanzanie, vient donc d'être lu par l'honorable juge Ntyam. La Cour va donc suspendre sa séance pour la composition devant être reconstituée en vue du délibéré dans l'affaire Alfred Agbessi Woyome contre République du Ghana, affaire revenant pour révision, affaire numéro 001-2020.